Good morning. Only one judgment. This judgment AIR 2025 Supreme Court 4898. AIR 2025 Supreme Court 4898. This is Division Bench Judge of Supreme Court. Dharmarao Saranappa Sahabadi versus Sayeda Arifa Parveen. In this particular one judgment, the Supreme Court elaborately explained Order 41, Rule 33 and 22 how to modify the degree. After obtaining preliminary degree, if anybody dies out due to that death, the share of a person who obtained preliminary may be increased or reduced, will be modified. So that is also practically necessary. Then Section 60 of Indian Evidence Act, which deals about evidence, adducing oral evidence or evidence to prove the character of the man. Then Section 50 Evidence Act, the relationship of the person. If there is no evidence of proof for relationship, the evidence of persons having special knowledge about that particular family may be accepted. Then section another aspect, Mohammedan law, gift, the procedures of gift. See, Mohammedan law have got a special permission from Transfer of Property Act 123 is not applicable to Mohammedan law. So how the courts accept the oral gift, that is also duly explained. Then Section 58 and 59 of Limitation Act went to cause of action arises, whether cause of action continuously goes on. Then question arises, Section 3, that is Transfer of Property Act, constructive notice of notice. Constructive, most important aspect which advocates must understand, that if any person is bound to know about certain facts, and if he failed to know about that certain facts, the court will presume that he is off the notice, constructive notice. Suppose if he goes to a person and purchase a property, he would have vigilantly aware about whether he is actual owner, whether his father was died and he is inheriting property, and if he is not doing all those things, that the court will presume that he is aware of the facts. These are the facts. Then specific relief act, section 34 and 31. So some advocates may think that this is a civil nature. Why should we strain to know about this? These provisions of Indian Evidence Act, section 60, 50, 73, all would apply in criminal cases also. So for Order 41, Rule 33, 22 is concerned, being a member of society, a member of family, there is possibility of you being faced such a position, you may require modification of degree instead of filing fresh suit. All these things will help you, so kindly go through that. Then I will come to just a gist of this case so that you can understand this one. Khatija B, wife of Syed Abdul Basit, filed her suit against her brother and got partition, possession of agricultural land. And thereafter what had happened, the Khatija B died, his husband obtained a mutation of records as a legal heir. According to husband, Khatija B have no issues, but later on some person filed suit stating that she is a legal heir of Syed Arifa Parveen for declaration that she is the owner of the suit scheduled property. The property was given to her by gift. So the lower court decreed the suit And then High Court has set aside it. Then Supreme Court, after framing several issues which I want to share with you, whether plaintiff proves that she is having right title ownership over the social property, whether the plaintiff further proves that she is in lawful personal enjoyment over the social property as on date of filing of this suit, whether the plaintiff further proves that defendant have interfered with the peaceful personal enjoyment of social as alleged in the plaintiff, what order or degree. Additional issues, whether the suit is barred by limitation, whether the suit of the plaintiff in present form is maintainable. All that Supreme Court has, by discussing all this, since for valid gift, oral gift in Muslim law, possession is most important. Here, on the death of Khatija Bi, her husband seems to have mutated all records and he was having all records and possession. Therefore, that was very old, 20 to 23 years back. Therefore, suit was also barred by limitation. I would request you to go through the entirety of judgment, try to read relevant portions so that you can understand that. And so far, the details of these provisions I will discuss in the tip for advocates and law student YouTube, wherein I will discuss these provisions of law for the students to understand, and it will also be helpful for you to understand this judgment. But this is the judgment. In one single judgment you can have abundance of legal proposition of law. Then another important aspect I would like to discuss with you, that the judgment also discuss about factum probandum. Factum probandum is something different from factum probans. Factum probandum is fact to be proved. Factum probans means as it is proved. Road accident as it is proved. And factum probandum, you have to prove it. You should understand these doctrines, phrases also. Best wishes.